lunch with Jeffrey.
All right,
Well, you're acquainted with.
we're gonna get started here. Welcome to the office of the Police Ombuds Commission meeting, December 2024. We have an action-packed agenda today, y'all. So welcome everybody. I like seeing people in the seats out there. That's fantastic. We're going to move to agenda and minutes approval.
I move that we approve tonight's agenda for December, is it the 3rd?
I second.
Okay, so there's approval in a second. All those in favor?
Aye.
All right. Okay, got a thumbs up from Amy. All right, that passes.
Aye.
Okay, thank you. And then, so that passes. What about the minutes?
I move that we pass or accept the minutes from September 24th, 2024.
Second.
Okay, we got a motion and a second. All those in favor? Aye.
Aye.
Okay. That passes. Thank you, Amy. So that passes as well. Okay. We're going to turn into public forum. Do we have anybody signed up to speak?
Debbie's not speaking. I got more.
So all of you are here and not one of you signed up to speak?
Debbie.
All right, Debbie, why don't you come up? I'll need you to fill this out after, okay?
And we do have a new timer system, so I will go ahead and give you 5 minutes on the clock.
Okay.
Can you hear me?
Yes.
Good. Debbie Novak, and I'm from the Spokane, Washington area. I just have some good news to share. Jenny Rose knows about it. I just told Lad about it. I think Bart knows. I don't know if Duncan knows yet, but our son, David Novak, that was shot and killed in January of 2019 by a Spokane City police officer. I have done a submittal to the Office of Independent Investigation, and his case has been accepted for review.
Wow.
So this will, review is like the second step of a 5-step process to get an entire reinvestigation. So what that means is that there's still a possibility for criminal charges to be pressed against the officer. And David's case is the first case on this side of the mountains, on the east side of the state, under Initiative 940. I can't quote you the WAC. I can't remember what WAC it is. But so it's not under the measurement or the bar of malice. It's what a reasonable police officer would have been expected to do. So, yay.
Yeah.
Yeah, so
Thank
that's.
you for sharing that.
Yeah, it's really good news. So it really is history, I would say, for Spokane. And the Washington Coalition for Police Accountability is one I give a lot of credit to for getting that new law passed. And it's going to help a lot of people. We have one other case pending in Stevens County, but that was for a case in 2015. I think it was kind of similar in that the guy got shot in the back while he was walking away from the police officer, but I do believe he was armed at some point, or he was armed when he got shot. But unfortunately for that family, the bar they need to meet, or the measurement they need to meet with that, is malice. And that's very, very hard, if not impossible, possible to meet. So wanted to share that with you. Thank you very much.
Thank you. Do we have any comments from commissioners?
No.
No?
Yep.
All right. Thank you.
Thank you.
Okay. If it's okay with the commission, I'd like to bring Mr. Duncan up. Yeah. You know, we talked about this. We talked about giving you a spot on the agenda.
Yeah, I didn't know this was going to happen.
It's probably my fault. I think I've told you a couple times that you're welcome to call me up anytime you like, so. Yeah,
Any thoughts, comments, things you want to share that are top of mind?
I don't have anything. I'm happy to provide any input or answer questions when you get to the 3 closing reports if you would like, but no, I didn't have anything I wanted to say tonight specifically.
Okay.
Maybe for the record, identify, Dave, yourself and what your role is.
I'm Dave Duncan, and I'm the president of the Spokane Police Guild, yeah.
Okay.
Okay,
Cool.
thank you.
All
Well,
right.
appreciate it. I'd just like to give you time.
No, yeah, and I'm here. I try to come to every meeting, and in case you have questions, I'll do my best to kind of answer and, give insight, yeah. It's a good process, and I appreciate it, yeah.
I
Thanks.
appreciate it. Okay, so we're going to move to, we don't have a guest speaker this month just because of how packed the agenda is. We're going to go to the OPO reports. So, Mr. Logan, it's you.
Yeah, normally at this point, I'd like to say Louis May,
Yeah.
but she's hiding. No, thank you. Good evening, Commissioners. Good evening, everyone. I'll just run through the obligatory numbers, and we'll go from there. I think you'll find that where we are at the end of October exceeds the numbers that we've been at for both 2022 and 2023, so we're ahead. We had a lot of contacts this month. We put 815 down, but a lot of those are due to the different conferences and things that we went to, which we would not normally be. So we did try to put an asterisk next to that. We have not captured that in the past, so that's new. But with that pushed our contacts for the year up to 2,732. So even if you took out those 800, we would be at 1,900 contacts. 2023, we had 1,820, and 2022, 1,715. So we were already exceeding what we had done in previous years. OPO interviews. I'm going to put this month into perspective because October was a travel month. We were out of the office for half of the month, and the numbers still stacked up per normal. So 7 OPO interviews, 123 for the year. Last year we had 83 total. We did, out of those interviews, put in 1 complaint. That complaint was from a community member that had a concern that they were given a DUI, but they were contacted while they were walking, and then they also had additional concerns about the towing of their vehicle. We had 4 referrals. One of them was external, and that went to the Spokane County Sheriff's Office. It was a community concern, and they were concerned about the lack of police response. And then 3 internal referrals. One was in regards to a community member that did not have their driver's license returned on a traffic stop. One that had a conversation with an officer about political canvassing, but they specifically did not want to file a complaint. And then questions about what was going on with the chop shop that the community member's motorcycle had been recovered in. Those are kind of customer service opportunities for the police department. That's the difference between a referral and a complaint. If it's something that we can do better, make something work for the community member, we'd like to go that route. So referrals 51 for the year. Last year we had 63. Cases certified was 4 for the month, 66 for the year. IA interviews, we attended 9. I actually attended 1 in the airport on the way back. So it's just trying to time these things when they happen. So 89 of those for the year, 94 for all of last year. SPD meetings way up, 53 for the month, 487 for the year. We had 415 meetings with SPD last year. Community meetings, we also had 8, 88 for the year, 76 last year. And then oversight meetings, 26, 112 for the year, as compared to 79 last year. So again, very, very busy month. We had the NACOL conference. As you know, I'm on the board of NACOL, so we also kicked that off ahead of time with the few days prior. There was a board meeting while we're in the same location. Following the NACOL conference, it went back to back. The International Association of Chiefs of Police Conference was in Boston, which we attended. And then midway into that, I went to Harvard and participated in an executive workshop. So as one of 7 oversight professionals from around the country, 7 mayors and 7 police chiefs that had the opportunity to not attend, we were actually invited. So Harvard paid the way, and we provided input on state-level accountability efforts in regards to oversight. So it was quite something to be invited to and be a part of. So subject to your questions, that'll be my monthly report.
So on the current, is that through the end of October or the end of November?
Correct.
End of October?
Yes, ma'am.
October 31st. Okay, thank you.
So can you tell us what was discussed at the NACOL and at Harvard, and what new developments are occurring nationwide, and any other new ideas on your business?
Oh, man. So NACOL, there's a lot of things discussed. My focus, I gave a panel with a gentleman from Minneapolis, and then also the moderator was from Harvard. And we talked about post boards and accountability systems at the state level. I don't talk about it here much, but I'm a commissioner on the Washington State Criminal Justice Training Commission, and I have provided a lot of efforts towards understanding the decertification process, which has become much more robust in Washington since 2022. As it turns out, as we were talking about that concept, I think it's important to know about it, and I think it's important to tell the police about it. So, because decertification should not be a mystical thing. It should be something that everybody is fully aware of. They understand it completely, and no one has any questions if all of a sudden you're going up for a decertification hearing. Typically, what we've seen, and all these things, it's all public record. It's all published online. The names of the officers, the different agencies they're at. It's all online on the Criminal Justice Training Commission's website. Officers are being decertified for things that we would expect them to be decertified for. A lot of integrity issues, a lot of sex stuff, just things that you wouldn't expect officers to be doing, and they'll lose their license to police. And when we decertify them in Washington, so we're trying to stop this idea of the wandering officer. So if an officer gets in trouble at one place, they resign, then they get hired because they've already got they pass the police academy, they can go and get hired somewhere else, and maybe try to make things happen without that misconduct actually being known about or even understood. So in Washington, when that decertification law came in, they put a whole bunch of different rules in place where if an officer leaves employment for any reason, the state has to be notified. So if there's any pending misconduct, if they were fired, all kinds of reasons why the state has to now be notified. So we're tracking that, at least inside of Washington, to stop that wandering officer or that wandering misconduct. Additionally, there's something called a National Decertification Index, which Washington does provide. When we decertify an officer, it is put, the officer's name is put on that decertification index. We can't stop another state from hiring that person, but that license to police is no longer valid once Washington takes it away, so they would have to take all that under advisement. So a lot of that kind of stuff. I think another thing that sets Washington apart is that we include community members on our decertification panels. In fact, if you go to a panel, or if you're put on a panel, there are 3 community members and 2 police representatives. So it's a panel of 5. And anybody, put my CJTC hat on. Anybody can apply to be on a panel. So now we'll take that back off and be the ombudsman again. Only one case so far has not been unanimous from the panel. So when it comes to conduct that officers are being decertified for, everybody is in agreement. It's not this thing that, oh, we're going to set these new standards and it's going to be an unfair system. They've all been unanimous except for one. So I think that's an interesting thing to talk about. But as we got deeper into this conversation, we started that conversation at NACOL, and then we continued it at Harvard. You know, when you talk about POST, and POST is Police Officer Standards and Training, that's typically what's used as the acronym for the CJTC in a lot of other states. So these are the requirements to become a police officer. You have to meet these. So when we want de-escalation training, implicit bias training, you name the type of training that's new, we put those into these are your basic requirements to be a police officer. So we have that, initial training standards. And then we have now in Washington, I would say that we are leading the entire United States on what we're doing with decertification. We have a robust set of standards for decertification. So we got the start and we have the finish. Well, I kind of think that if we're doing our job right as oversight, we never have to get to the finish because we work on these accountability mechanisms early and often, so that those officers never approach what might be required to become decertified. So I kind of left Harvard thinking that's where we need to focus our efforts, that initial supervisors, that feedback, that coaching, that mentorship. You know, a lot of these things, and what we'll talk about a little bit later, use of force review boards, there is feedback that comes out of those boards that never necessarily makes it around to that officer so that they actually pick up those new tools that might help them in the future. You know, when we go to review boards, we're talking about conduct that occurred before. You know, if we're on a review board right now, it's anything that happened from this moment behind us. It's already been judged, it's been adjudicated by the chain of command, the police chief, et cetera, and decisions have been made. So our job as review boards is to analyze that stuff and decide whether or not we want to see that particular thing happen again. Because the work of the review boards for the future. And we have to be very, very critical. If the action was right, if the action was lawful, if the action was appropriate, we get to slap the table and say, that's fine. In similar circumstances, we would expect a similar result. Maybe there's not a way that we could mitigate that or avoid it in the future. But if there is, if we have an idea that that could have been avoided, it's incumbent upon us to give that tool back to that officer who actually went through that thing so they have that extra tool. We don't just talk about it in a room off to the side. We have to give them the tools if we want different results. So that's kind of, in a nutshell, 3 weeks of talking on accountability systems. And when we say accountability systems, again, I want to be clear, it's not about firing officers. It's about making officers better, making sure that they're following policy, making sure they're following constitutional policing standards, and making sure that they can operate in a safe manner for them. So that's accountability, and that's kind of what we were talking about. So right now I'm kind of stuck in the middle. We have the initial standards, we have the final standards on decertification, but really all our effort really should be applied in the middle so that we never have to get to that final standard.
Appreciate that question and follow up. You know, moving us along here, so I'm looking, we have 3 closing reports, we have elections, and then we also have executive session performance review. So we got an action-packed agenda. So if we could move forward to those 3 closing reports.
I do have one request, if we can speak into the microphones. Move them closer to your mouths, please. Thank you.
Yes. Okay, first one we'll talk about real quick is K24007. The closing reports, the drafts are in the packet. Should they be approved tonight, the recommendations be approved tonight, they'll be online tomorrow morning, so you'll be able to get all these. I will say that we went through these reports per the guidelines set forth in the Police Guild contract with the Police Guild last week, I want to say. Where the guild came in 5 members deep. It was the most robust. It was excellent, right? Because normally we have a chance to talk to just 1 or 2. I think it did expand the review, well, several hours longer than normal. But all of a sudden now, instead of just talking to 1 or 2 members, we get to talk to 5. And then they get an understanding of the things that are inside our minds, and we get a greater understanding of the things that consider them. We'll take that one step further. One of the members who came in was actually involved in one of the incidents that we wrote a report on. Well, that changed the dynamic of that conversation a little bit. And so then we're getting some firsthand feedback from an officer who was actually involved in the incident that we're doing a review on. I had a conversation with President Duncan just prior to coming down here. I'm thinking if they're amenable, I'm amenable to getting that firsthand feedback from officers as we write reports. Maybe we can figure out how to do it before we get too deep in the report so that maybe we can have a real objective standard. But I think that will enhance our reports moving forward. So if they're willing to do it, I'm certainly willing to do it. And I thought it was just an excellent thing, and we stumbled into it by accident, I think, but I think it was really, really good. So K24, I think 007 is the first one we'll talk about. It's an incident that occurred on May 29th, 2024 at about 2:30 a.m. Officers on patrol sees a suspicious person. And you at 2:30 a.m., lots of folks can look suspicious on the road, especially when they see a police officer, they kind of turn and start going in the opposite direction. Caught the officer's attention. Officer thought he knew the person, and so ran their name inside of their computer system and realized that they had a warrant for violating a protection order. So that they attempted to make contact with the person. The person denied being who the officer thought they were and promptly left the area. During that process, dispatch actually informed the officer that if it was that person, they also had an active first-degree burglary warrant. So they were interested in making contact. But by that time they got to that point, the person had fled from view down a corner. So they set up a perimeter, 2:30 in the morning, not a lot going on. So they had some officers come out. They had a canine come out. It's dark. And all of a sudden, the area where they believed the person was in was a pretty wide open area. So they brought a canine out, and they used the canine to track the person. So on page 8, these are some of the examples of announcements. If ever you're in an area and a canine is being deployed, you're going to hear a lot of loud announcements from police officers. You're going to hear something like, "Attention in the area. This is the Spokane Police Department. Suspect, you're under arrest. You're being tracked by a police dog. If he finds you, he may bite you. Give up now. If you do not give up, we cannot guarantee your safety. Attention, citizens in the area. Stay in your home." And that's not just given by the person running the dog, but they're given by multiple people to make sure that people know that there is an event there that they don't want to be involved in. And to give up, right? The more announcements, the more chances that you're being told that. I know for me, someone says dog, I'm giving up right now. Because dogs are very, 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 very fast, and they're pretty good at what they do. So in this case, they used the dog for tracking. Now, if you recall, a month or two ago, we did a canine report or a closing report on a canine incident where they actually tracked the person down, found that they were under a car, and then our questions were there any other alternatives instead of having the dog latch on, bite the person, and cause that kind of more intrusive damage. So because we had just done a report on that, this one kind of sounded similar. It's what caught our attention. So we decided to take a look at it. So in the process of tracking this person, The dog eventually alerted on them. They were kind of in a lot. There was a car up against a fence, and they were hiding underneath the car. So one of the questions we asked was the dog on leash, off leash? Do we just let the dog go? So the dog was on leash, but it was a longer leash. And when they're tracking, that's often the case. The dog will have a little bit more leeway. Usually when they know where the subject is or the dog alerts, they'll shorten that leash so that the handler will have a little bit more immediate control over that dog. In this case, the alert and the contact was almost simultaneous. The dog did make contact with the subject. In the police report, they estimated that the bite lasted approximately 20 seconds. When I reviewed the body-worn camera video, it seemed like it was less than that. But once the dog is on, the dog's going to stay on until that person is brought out and taken into custody. So there is a bite, the person's pulled out from underneath the car, put in handcuffs, and the dog releases. All that happened. So as we're looking through this case and looking at that, we realized that we found a couple of areas that could be more clear in policy, which is why we decided to write a report on this. So SPD's guidelines for canine use is pretty general and it provides the threshold that canines can be used to locate and apprehend. So we have one set of justifications for location and apprehension. When we look at Seattle's policy, they have separate standards for both. So you can use these standards for location of or tracking of suspects and then use these other standards for any sort of apprehension. So we like that. When the location of the subject, where they are hiding, has been determined, we believe that handlers should not use the canine to do a direct apprehension if alternative tactics are available, safe, and feasible. And some of those things that they can use that we have in our inventory, we have chemical munitions, like OC, pepper balls, that sort of stuff. Things that might be able to draw that person out in a safe manner without causing that intrusive kind of injury that a canine bite might do. So our first recommendation 24-10 is that we recommended that SPD should, can you put that slide up, please? Just to make it easier, we put individual recommendations on slides so that you can read them as we go. So it should update its canine policy to require all reasonable efforts to avoid unnecessary and, okay, we're going to take out one of those unnecessary and unnecessarily injurious bites. When the location of the subject in hiding has been determined, handlers should not direct a direct apprehension if alternative tactics are available, safe, and feasible. And we are simply looking to have that put into policy as a separate thing. Wow, that is still really small, isn't it? We had this discussion in the office of making the font bigger. It's just really, really small. I apologize. Because these recommendations are wordy. So then when we're doing the review of a canine application, we believe that there should be a separate tactical analysis for the location tracking, but then also the direction for the apprehension, instead of just combining it into one. Just because it's the proper tool to use for tracking doesn't necessarily mean that the resistance in the government interest is appropriate for the actual apprehension if there are lesser means available. So that's recommendation 24-11 in a nutshell. And then I'm getting feedback over here. I don't know what's happening all of a sudden. So then the third recommendation that we had, 24-12, was when we're watching how this went down. Normally when there's a use of force case that happens, an uninvolved supervisor comes to the scene and starts to begin an administrative investigation into the matter. In this case, because it's canine kind of operates under a little different. they operate a little differently, let's just put it that way. And if a canine supervisor is not available, the actual handler themselves will go and conduct that initial admin investigation into that use of force. And it makes it a little bit weird, because all of a sudden, the person's in the hospital being treated for the injuries from the dog bite. They've been read Miranda for the criminal side of things, and now all of a sudden, we're asking them separate administrative, investigative kind of questions, which puts them in a weird predicament. So we believe that an uninvolved supervisor, whether it's a canine person or not, should be the person asking those administrative questions and not the person that actually used force on that person. Because we want to hear from that, from the subject's perspective, what was going on in their mind, whether they heard the commands, and whether the appropriateness, that sort of thing. And we think it should be like every single other use of force that we have. An uninvolved supervisor should be conducting that administrative investigation. So that is the third recommendation from K24007. Any questions on that one?
I have a question.
Yes, ma'am.
The incident started at 2:30 a.m. The dog went after the suspect at 8:29 a.m. Do I have that correctly, that 6 hours were spent?
This is where I'd like to say Louis May.
Louis May? That seems like an awful long time. Maybe I'm missing
That's
something.
probably a typo.
Starts out at 2:30, and then on page 8, the last paragraph, at 8:29, the canine alerted on the subject, and Officer B gave their canine the command in German to bite or hold. The 6 hours seems like a long.
It wasn't that long. It was
Oh,
the middle. It was
okay.
the middle of the night still. So, what page was that on exactly?
Last paragraph on page 8, and then, of course, the time incident is on page 7, halfway through starting the closing report, basically.
Oh, 8:32, right there. That's the time on the body-worn camera video.
But it says incident at around 2:30 a.m. is when Officer A was patrolling and saw the suspect and asked him to stop.
So that last paragraph on page 8, we're referring to body-worn camera timestamps.
Right. But the incident started at
minutes and
2:30
seconds.
a.m.
It's minutes and seconds.
But oh, I get it.
Yeah, so if it's like a 20-minute long body camera video, that would have been 8 minutes and 30 seconds
Got
into
it.
that body camera video.
Okay,
Yeah.
all righty.
So we're
Thank you.
trying to,
Got it. At 8:29 on the body cam. Got it.
I'll make that clear before we publish. That's a great catch. Thank you.
And there's one more recommendation for this, right? The 2412, did you already?
Thought I did
That
that.
was the last one.
Okay, my apologies. So, any other thoughts or?
I thought they're great recommendations. I mean, they're great ideas.
Okay.
Quick question. Do you sometimes go through other canine incidents in the past to see if there's a similar trend going on or a theme? Or is each one uniquely different from each other?
I think we have not for some time. I would say that right now we're taking cases as they come in, and there have not been groupings of canine utilizations that close together to make us draw trends. I would say, when I first arrived here 8-9 years ago, you were seeing a lot more canine utilizations and dog bites, and they've gone down quite a bit in those years. Some of that had to do with our first closing report and some of the scrutiny put in by the police department when when we started talking about dog bites, they brought in someone new to run K-9, and that lieutenant did a robust overview of their policies and procedures and changed some different things. Right now, I think we'll get a little bit more with some of these recommendations. When we briefed the chief, he didn't say yes or no, but he sure did not turn away. In my conversations with Chief Hall so far, he believes in proportionality, he believes in the least amount of force necessary, and those sorts of things. So I think that we'll see even greater improvements towards those K-9 moving forward. I think the key is that what we don't want is if we're using dogs for tracking, and they're very effective tools for tracking. We also have drones. Drones can go up and you can see things from an area. They're a valid tool at night if they're available because they have some heat signatures and you can see where folks are. There's some thermal stuff happening, and so we have some alternative tools. So there's options, and we want to give our officers as many options as they can, but we also want to use the least amount of force necessary in order to apprehend subjects. So,
Okay,
yeah, I
Thank
don't
you.
know. That's a
All right. So
helpful, thank you.
do we want to move for a recommendation of K24-007 with the revisions?
So I move that we approve, is that what you're asking for? Okay. I move, it's on page 14, list all three of them. I move that we approve the recommendations 2410, 2411, and 2412.
Second.
Okay, we got a motion and a second. All those in favor, aye?
Aye.
Aye.
Thumbs up. Thank you.
Aye.
Amy. All right, that passes. With the unnecessary taken out, one of those unnecessaries, right?
Well, I think it says unnecessary and unnecessarily injurious, so I think it's technically okay.
It's okay.
Grammatically.
Let's move to the next one.
Yes, sir. So the next case will be F23054, which occurred on September 21st, 2023 at 7:30 p.m. It's kind of been on our list to write on this one for a little bit. In this case, officers were responding to a possible assault. A group of dispatch informed the officers that a group of people were beating an individual who was on crutches. So as officers were en route to the scene, they observed a person riding away in the opposite direction on a bike carrying crutches. So the officer concluded that the person was likely involved in the call in some way, and they attempted to make contact. And the way they attempted to do that was, we call it a bike stop for lack of a different term. They flipped on the lights on their vehicle, spun around and attempted to stop using their emergency equipment. Person looked back, took a look, and decided they did not want to stop. So this is when the body-worn camera footage starts. And the way our system's set up right now is that body-worn camera starts the moment the officer presses the button, but it goes back 1 minute. So it's always kind of running. There's 1 minute that exists in buffer, and that minute doesn't have audio, but you can see what's happening. So the audio actually starts the moment the officer hits their button. And so that's when it starts. So there's 60 seconds without that. During this 60-second period, the officer pulls alongside the bike. They identify themselves as a police officer. They actually have their door open, so they're talking through the door, not through an open window. So they have a door open as they're kind of driving alongside this person, identifies themselves clearly as a police officer according to the police report, and they tell them to stop. The subject says they didn't do anything wrong, and they continue to ride away. And then they approach this construction area where there's kind of a gate that they can't fit through riding their bike, so they have to get off their bike and kind of walk through and pull their bike through. The officer has stopped the vehicle at that point in time, has gotten out, and has chased this person. And as they're trying to get through this kind of gate blockade, tackles them. So in the process of tackling them, the audio doesn't start until the officer's actually on the person. So in that minute, there's a lot of action. You can see it, but you just can't hear it. And while we were at NACOL, actually, I took the time, Axon had set up a booth there. So I went and I asked them, I said, how difficult would it be to turn on audio during buffer mode? And of course, the person didn't know, but they said they'd find out. And then they chased me down about 20 minutes later and said, you just click this one button here. So all of our body-worn cameras have a function that you can just slide it. Although speaking with the Guild, that is, body-worn cameras is a mandatory subject to bargaining. And there are reasons why you might not want that audio on. When you're reviewing force, though, more information is always better, is kind of our thing. So that will lead to our first recommendation, which is 2413. And on page 11, I notice it says recommendations in here twice, so I'll remove that from the draft.
Mr. Lowe, can you go back to, what do you mean as far as there are some situations where you wouldn't want?
That's my question, too.
Can you,
Elaborate.
do you mind elaborating on that? Yeah.
What if you had just left the bathroom? What if you were having a private conversation on the phone on break? What if you were having a discussion on confidential matters? There are certain police discussions that we don't expect to be on body-worn camera footage. I think those are some good examples. Detective Duncan, would you like to expand on that idea?
But you wouldn't have your camera on if you're coming out of the bathroom. This is
Correct, but it goes back 60 seconds.
So you're not actively recording, but your camera is on. And so even though you haven't pressed the button for it to, now I'm recording, it is always recording. And so once I hit the button to activate it, my recording is from that minute, that second on with audio, but then also it gives you the video 60 seconds prior to me hitting that button.
That would be a very unique situation. You're coming out of the
Yeah.
bathroom and there's an incident going on that you need the body camera on.
Yeah, and you know, I'll make the other argument for why it would be good to have that audio. You know, if I'm walking down the street in uniform and some citizen runs up to me and like, you know, there's someone with a gun over there or whatever, like my first reaction is to run and go to whatever the problem is.
Okay.
It may not be my first reaction to like, oh, I got to better turn my body camera on. So I run over there, you know, shooting happens, something happens, you know, and then it's like, oh yeah, I hit my camera. Well, you're going to have no audio prior to me hitting that camera. So in that instance, yeah, it would be beneficial to have that audio. It's a bigger question that I can't say that I think it's good or bad, and I think many people you can make all kinds of arguments either way. And some of the reason why I could be wrong, you know, I mean, Washington is a two-party consent state, so if I'm walking around with my body camera and I'm, you know, capturing audio without letting you know, like, you need to let people know when you're recording them. So I think maybe the audio could be an issue there. I don't know, but yeah, something that I'm always happy to discuss with the city if they want to come forward with changes. Good recommendation.
Yeah, and I think we could get past the two-party consent thing just with how they find officers and their use of body-worn cameras. But the conversation doesn't start if we don't make the recommendation, which is why we decided to make the recommendation, bring it to the table. SBD should turn on audio during buffer mode on body-worn cameras recordings. Now, there is also going to be battery life issues and how it might affect how long those cameras actually last. I think some of these new versions of cameras that they're having are a little bit better with battery efficiency, but there are some things. But I still think it would sure be nice to know what was being said during that minute, especially on use of force. Now, if the body-worn camera is activated on time, normally not an issue. In this case, it kind of was hit as they made contact with the person, so there was, and it wasn't while they were responding for however long it took them to get to the area. So there was some build-up time. But in this case, we lost a minute, we lost all the commands, we lost any of the resistant audio, and I think it would make sense. And especially since it does not require new equipment, it just requires a software switch. We thought we'd make that recommendation. So in this case, when we, and this is stuff not known to the officer at the time of the tackle, right? The officer suspects that this person is involved in this assault. They don't know if it was the assaulter or the assaultee. They don't know anything, but they do know that they did ask the person to stop and the person did not stop. So that part is known to the officer at the point in time. So all this extra information we find out after the person is kind of taken into custody. And then we realize that they were in fact the victim of the group assault. And that's where you kind of start doing Monday morning quarterbacking, right? And you go, oh, isn't it terrible that we had to use force on somebody that was a victim of the assault of the call that we were actually coming to? And then our actions, and the subject's actions as well, to be fair, had they stopped, there would have been no need for a tackle. But they did not, and the tackle happened. But then during the process of that tackle, we actually injured that person to a much more greater degree, and they ended up requiring some surgery. So some of these other recommendations will come out of that. On review boards, we want to really know if there was another way to do things. And when you look at what the officer knew at the time, the subject's actions at the time, we understand that why the tackle occurred. Some of the chain of command review comments, though, were more troubling because they focus on the fact that had that person not complained of being injured, that we wouldn't even have to review this. That's why we went a little deeper into some tort law. And if someone is injured at our hands, whether they had pre-existing injuries or not, we're still going to be liable for that in Washington State. So we wanted to add a section, and I guess I'm skipping one, so let me go back. So recommendation 2414, it's less prevalent now, but it used to happen all the time. If someone was going to an assault, an officer would ask, do you want to be a victim? Or if anything had occurred, do you want to be a victim? And if the person said, no, I don't really want to be a victim, then we wouldn't necessarily take a police action on the person who assaulted them. So you don't have to want to be a victim of an assault to have that other person commit a crime against you. So officers can still take action on people. So we would like them to get away from that practice of asking whether or not they want to be a victim. So that's 24-14. The 24-15 recommendation had to do with the aggravation of pre-existing injuries. So when we talk about reportable force and reviewable force, we've kind of had this conversation before. There are a number of types of force that right now are not being reviewed by the chain of command. They're still reportable inside a police report. So if I took you to the ground and you didn't get injured or something like that, I would still have to document that I took a police action against you and put it in your report, but that would not be automatically reviewed by the chain of command. So if they complain of injury, that is a reason why a lower level use of force, such as a takedown or a body weight application, would be reviewed by the chain of command. If we aggravate pre-existing injury because there is liability that gets associated with the police department on that, we believe that we should have those automatically reviewed by the chain of command, and that way the department has much more documentation in regards to those cases. So that's 24-15. And then 24-16 has to do with the conduct of review boards themselves. And we'll talk a little bit more about that after I'm finished this third case. But there's this thing called hypothetical danger. I like to call it the unicorn defense. Everybody has a different way to look at it. When you're looking at force, especially the more severe forces used, let's just say deadly force, terms like imminence and immediate danger become very, very important. And immediate and imminent danger can't be something that you think could happen. Like they could have gone inside of a building and there could have been somebody walk by, or they might have had a knife, or that's not immediate. It's something you don't know, so you can't apply those the same standards towards that. So hypothetical danger, when we talked about were there any other steps the officer could have taken prior to using force, one member of the review board stated, well, we could have used lethal force. So that's exactly opposite of what I would like our review boards to be doing. I don't want us to be justifying force by saying we could have done something greater. In fact, we expect our review boards to come up with alternative means or alternative tactics to include de-escalation and all those things to avoid force if at all possible. When we're saying, and at the review board time, we know all the facts, right? We have the investigation, we have all this stuff. We know it was the victim of an assault. We know that we actually caused more damage to the person who was already hurt, who was already assaulted, and ended up needing surgery. Is there any way we could have avoided that? That's the purpose of the review board. Because no, we would not want to see that same scenario again and again and again. We hope that's a one-time thing. Again, it's historic, and the review board's purpose is for the future. So this recommendation was specifically towards review boards and tightening that up so that we are actually providing greater emphasis on alternatives to force and de-escalation if those situations are possible. If you have 7 people in the room that agree, or even if they don't all agree, the majority agree, yeah, it's not feasible to try some of these other things. That makes sense. That means that operator or that officer is operating in a manner of which we would expect. So that's for that 2416. Subject to your questions.
Yeah, I have a question, Mr. Logue. So I'm not sure that the review board members' comment that they could have used lethal force can be just ignored, and maybe that needs to be clarified. It's my understanding that the officer knew that there was an assault. He didn't know that it was a felony assault or misdemeanor assault or what it was, and a review board member is saying that the policeman could have used lethal force. Now, that's not my understanding of the law. What is your understanding?
I think when someone's using lethal force, there has to be an immediate danger to that officer or to someone else.
Okay, so did the other members of the review board just kind of go along with that statement, or was there a correction, and maybe it needs to be corrected now so that the people who are reviewing this tapes in the future won't get the idea that a police officer can use lethal force if somebody's basically not stopping for him.
Yeah, that's what we put in this paragraph. I'll just read it. At the review board, a question was asked if there were any other steps the officer could have taken prior to using force. One member stated that we could have used lethal force, citing personal experiences. Several members of the board also justified the action, citing examples they experienced where the situation was worse than this case and cited hypothetical dangerous scenarios. One member even stated up to lethal force can be de-escalation. That's why we then followed up with the Department of Justice investigation on the city of Phoenix. This is at the bottom of page 12 in this report, where they found that Phoenix PD engaged in excessive force, including deadly force, and the officers used unreasonable force to dominate encounters within the first few seconds and failed to employ strategies that avoid force. They found that Phoenix's training has encouraged officers to use force when it is not lawful to do so, and to use serious force to respond to hypothetical and not actual danger. And we feel that that puts officers and others at risk, and it results in constitutional violations. So we felt it was important to at least highlight that as something that we don't want to see from review boards.
We do have Commissioner McCollum who has a question. Go ahead, Amy. You're on mute.
Okay. Greetings from Connecticut. My concern is what you were talking about the de-escalation, like the alternatives being de-escalation. Like I'm at a use of force conference with lots of officers right now. And in one of the sessions, they referred to de-escalation as a weapon being used by people who are trying to like basically say it's a use of force because you didn't de-escalate. The idea that force is a de-escalation is absolutely ridiculous to me. And then I also just wanted to point out like that, so I did a deep dive. I reread very deeply all of the 16 reports that were written from 2020 until 2023. And basically, they all, 8 of them, half of them, had recommendations about command reviews, like review board reviews. Chain of command reviews seem to be a large problem with our department. So I'm really glad that, especially recommendation 2416, if we don't have the right people on these boards who actually understand de-escalation tactics and who actually are willing to talk about alternatives to what happened rather than just backing up whoever did what they did, I think that those review boards are not going to be trusted by the community. So I really do think it would benefit the department to do some serious look at chain of command reviews, because that has been a repeated recommendation in half of your reports. This is very similar. So I just wanted to bring that up, that this is something that's actually in different ways been talked about before. So this isn't even the first time we're hearing about it. So I'm really glad that this is in here. And the part about analysis, like I don't see really deep analysis in anything that the command people said. And if there is no, if they're just stating facts that happened without any analysis, that doesn't feel particularly useful to me. So those are my comments. Thank you.
Yeah, I echo the same thoughts. Okay. So thank you, Amy, and we could, how about we move forward, because we got another.
Yeah, I just want to do a real quick clarification. This is pretty minor on what we've been talking about, but the recommendations on pages 11 and 12 don't comport with how they're laid out on page 14. Like I don't see recommendation 2413 being the same on page 11 as it is on page 14. Just FYI, if you're...
We'll double check that.
Yeah, okay.
Yep.
Anyway, okay, thanks.
That's a good catch.
This is a really good catch. Thank you. And I think there was one recommendation which we decided to remove as a result of some of our discussions in the drafts. So thank you for that. I'll double check that before we publish them. But the 4 that are in the actual report, which I just went over, those are the ones that are specific.
Okay, so that's what we'll vote on.
Yes.
Yeah. Do I have a said motion?
I'll make a motion that we approve case F23-054 with recommendations 1, 2, 3, and 4 on page 14, which would be 20-13, 24-14, 24-14, 24-15, and 24-16 be approved.
I think we needed, if I heard correctly, we needed the recommendations that were on page 11,
Oh, I'm
12, the ones written there in
Oh, I
the
see the
report
reverse.
instead
Okay.
of on page 14.
Okay, so I'll revise that motion to approve recommendation 24-13 on page 11, recommendation 24-14 on page 11, and recommendation 24-15 on page 12, and recommendation 24-16 on page 13.
Okay, you have a second?
I'll second.
We have a motion and a second. All those in favor, aye.
Aye.
Or thumbs up?
Aye.
All right. That unanimously passes. Just want to do a time check, y'all. It is 6:32 currently, and we're heading to the last report.
This last report's F24038. It happened on May 20th, 2024 at about 12:15 PM. I'll compress the story a little bit, but at the end of the day, it involved a stolen vehicle that was stopped by police. At the point that at some point after the vehicle was stopped, there was a passenger from inside of the stolen vehicle, and it was a known stolen vehicle. The officers had gone so far as to contact the owner, and the owner had given permission to follow it, and so that we could maybe see where it could be going, and it was a known stolen vehicle. So the passenger from inside of the stolen vehicle decided to, while the vehicle stopped, the driver's outside of the car, to bolt. They left the driver's side door and took off running into this apartment complex. Officers pursued on foot. A lot of verbal commands were given. As the officers catch up, well, actually, just prior to the officers catching up, the passenger, we'll just refer to them as the passenger at this point in time, is a juvenile male, but turns around with their hands up and says, "Sorry, I didn't know." Slightly after that, the officer makes contact with the passenger. What is not seen on the body-worn camera, you cannot see it. It happens off frame, and the body-worn cameras are normally worn dead center of the officer's chest, so they show what is immediately in front of this person. They don't show anything that's off to the side unless they're a few steps back, right? It's a frame. So what is not seen on video is the actual contact. You see a person turning around, and then all of a sudden you see them going backwards and kind of like feet getting. So my expectation is that there's some sort of shove or something that happens right at the moment of contact, which would make sense following the end of a foot pursuit. So as the body-worn camera picks up from that moment, you see the officer's fist coming across the side of the juvenile's face. So that's where we kind of look at what occurred, because we can't see it. So you go off of what the officer says, and then obviously what the person who endured that force thought at the time. So the officer says that what is not seen on camera, that at the moment that they arrived, the passenger took a swing at them and then dug their nails into their arm, which caused the officer to fall on top of them, and then the officer struck them to break up that behavior. One version. Officer's version, they swear it's the truth, they sign it under perjury. We usually take that at face value, unless there's questions that are clearly there. The passenger's side, though, says, "I didn't do anything." It's not abnormal for someone to say that. But the officer punched me because I ran. This was said to a supervisor, and now we kind of have a dilemma. We have two sides of the story. We can't see exactly what occurred. So my expectation of a use of force review, like in the chain of command review, if there's a question about conduct, so the pastor then essentially made an allegation that this officer punished them for running, essentially. This is not addressed by anyone in the chain of command as it went up the review. And that's the error here. In my mind, what we would have liked to see in this use of force review is once there's a question about behavior, it then goes to internal affairs. That's what the policy says it should happen. Then internal affairs could then conduct interviews so that we can get more specific and direct information. At some point, that video is never going to be there, right? But before we had body-worn camera video, we had to do investigations without having that tool. But someone will have to make a determination. But when someone makes a determination on whether force is proper, it should be based on all the facts that we can have available. And in this case, it was not referred to internal affairs, and then everyone seemed to ignore the statements. So that's kind of why we chose this case for review. After what Commissioner McCollum just said, our first recommendation, 24-17, is also in regards to review boards. And I'll read the paragraph right before, not quite all of it. When discussing how a technique that goes against the Defensive Tactics Manual and to be suggested to be within policy can be reconciled, a member of the Use of Force Review Board raised the issue that the Defensive Tactics Manual is not part of SPD's policy, it is only referenced. Not following the tactics provided by the Defensive Tactics Manual is not a violation of policy. And then the member even questioned why we needed a Defensive Tactics Manual at all. So in the past, we have recommended that specific tactics and approved techniques be actually put inside of the use of force policy, right? And it's always kind of been avoided. The excuse is, oh, our policy manual is 1,000 pages long. We don't want this extra thing. But if you think back, go back to 2016, the Department of Justice was actually in Spokane doing something called collaborative reform with our Spokane Police Department. It's usually in conjunction, it's an agreement, it's not necessarily mandated by law, but they are reviewing certain things to try to make sure that the police department is operating within constitutional mandates. At the same time, we have the Seattle Police Department, who was under consent decree, also by the Department of Justice. So we arrived in 2016, and a lot of the comments from the police administration at the time was we have the gold standard policy, use of force policy. Well, our policy at the time was 5 to 6 pages long, and it was very, very permissive. And you might recall some of the commissioners that were here at the time, we actually undertook a review of 100 policies from around the country. And we took the best pieces of these different policies, and we put something together for Chief Meidl to consider updating his policy. And he actually took a lot of those recommendations. Chief Hull has just asked us for that information, and he's reviewing it again. So it's very interesting to see where this might go. But when we did that, we actually put our policy in compliance with Washington state law that they put in 2022, 3 years ahead of time. So we had to actually improve those policies up to that point. But there was resistance in talking the specific techniques that we were going to allow. And the reason they gave was policy would be too long, and we have the Defensive Tactics Manual. So you can't have it both ways. We're either going to say, this is policy, this is how we're going to operate, or it needs to be in policy. So that's kind of where this first one comes from. So we believe that SPD needs to really safeguard the reputation of the Use of Force Review Board by placing individuals who have working knowledge of SPD policies and procedures on those boards. And they should be people willing to critically analyze those actual uses of force. If we're just going to say we can do all these things, it goes opposite of what review board should be. Our job isn't to say in policy or not. That's already been done before it comes to the review board. Our job is to say whether or not we want to see this thing happen again. And if we don't, then we get to critically analyze that thing and come up with alternatives. So that's that first recommendation, 24-17. So you probably heard me talk about exceptional techniques before. I'm not a fan. Mostly because we come up against exceptional techniques more often than I believe there should be exceptions. If an officer is involved in something and they're losing or whatever, and they grab a rock or they grab the radio or they use something that's not an approved device or they use some sort of force that's not clearly spelled out, but it's this exceptional circumstance where they're losing, I don't have any questions about that. No one's taking away those exceptional circumstances when an officer has to do what they believe they have to do in order to go home safely. No one's asking for that. What we are asking for is that we don't use exceptional techniques as a coverall to cover uses of force that would normally not be in policy. In this case, we had a fist strike to the face of a juvenile. And they didn't even determine it to be an exceptional technique, but they still found it within policy, even though it clearly falls outside of the mandates of the DT manual. So our recommendation 2418 says that supervisors should clearly indicate in their reviews when a use of force is outside of policy and should be considered exceptional. Because we can't make exceptional even more loose than it already has been. Now, again, we talked in previous months that SPD is going to go away from using that terminology. Chief Hall has looked at me in the eye and says, when I specifically asked, are we going to get rid of the actual techniques or are we just going to get rid of the terminology? I like where Chief Hall's stance is right now on that, but I'll let him speak for himself. Exceptional techniques should be carefully reviewed. In the Defensive Tactics Manual, it says if we use it, we have to explain why this was a necessary thing. And that way we can provide the amplifying information that will go to the necessity and appropriateness of why we use that technique. So again, 2418 is a recommendation regarding exceptional techniques. 2419 gets into communication strategies for de-escalation. If you are giving a command to somebody and I want you to comply, if time and space allows it, I should give you, I should have an understanding that you've heard the command, that you understand the command, and you have an opportunity to comply with that command before I use force against you. Now, sometimes things are pretty dynamic, and in this case, well, let's just use me for an example. If I'm chasing you, and you stop and you turn around, my brakes aren't as good as they used to be. And there might be some contact between you and I as I'm chasing you. So a second and a half, a couple of seconds, I can understand some of that. If it's 20 seconds, okay, I have far less reason to be able to say there's momentum or this and that, or I didn't give that person a chance to comply. But I really want to know, because the officer said, if the passenger had shown, and this is a paragraph right above it on page 17, the indented thing, if the passenger had shown any sign of de-escalating or any amount of compliance, interestingly enough, he said the passenger needed to show the de-escalation, not the officer. That's opposite of kind of what we're talking about. But had the passenger showed compliance, I would have continued verbally speaking with them and would not have taken them to the ground. But you see them do this. So at what point are we asking for that compliance? Because there is a sign of compliance. So at which command, the person needs to know what they're being asked to do before we force them to do it. So that's recommendation 24-19. 24-20, I had a conversation with Chief Hall on this today. We're going to do a review on some potential de-escalation programs that are overarching, so a comprehensive de-escalation training program that is evidence-based with measurable outcomes to determine the effectiveness of it. That's 24-20. And then 24-21, questions regarding uses of force, such as that gap between what the passenger said and the officer said, we believe should be investigated rather than reviewed. So this is especially true in uses of force where an officer and the subject have conflicting recollections of the incident that create disputed facts that go to the heart of the matter of whether the force is justified. So that's 24-21, subject to your questions.
This one, in my opinion, is troublesome, and it's hefty. There's a lot to it, and I just hate to see de-escalation not being used in something that seems obvious. Man, it's easy for me to say I was not there, but this is what we're all trying to accomplish, is de-escalation, and also understanding what is being asked of this, what's being asked of the subject. And if there's confusion there, boy, how many times has there been a really wrong outcome across the country when the subject did not know what was really being asked, and there was some confusion and not enough time being given to make sure there is comprehension or understanding. But I really appreciate the work that went into these recommendations, because this is really what it's all about. Yeah.
Thank you, sir.
We have Commissioner McCollum.
Hi, yeah. So yes, I agree with the de-escalation training part. Absolutely. I mean, really, I think that we need, in uses of force, we need officers to actually write in their report what tactics of de-escalation they used. And I think them learning specific tactics will make that written report a lot clearer, and will make clear to the citizens out here, like me, that some kind of de-escalation was tried. If they don't write it in the report, it's easy to assume it didn't happen. So I think writing something very specific could be helpful. Also, I do think, training in de-escalation, I don't know how often they do de-escalation training, but maybe they don't do it quite often enough. And maybe some refreshers would be called for in this way, because you don't learn something from just one time. It needs to be repeated. And so one de-escalation training once in a while doesn't feel like enough. So I'm glad that this recommendation was made, and I'm really appreciative of you guys doing the work to come up with some suggestions for how to improve this policy. So thank you for that.
All right.
We need approval.
Yeah. So, if we can get a approval on F24-038.
I move to pass a motion for recommendation 2417, 2418, 2419, 2420, and 2421.
I second that.
Okay, there's a motion and a second. All those in favor, aye?
Aye.
Aye.
All right. Well, thank you for that, and very comprehensive, Mr. Logue and Louie May. We're gonna head into.
I have just a little bit more.
Oh, go ahead.
So I just want to let you know that for the last couple of weeks, and you can see that we have had several review board kind of comments inside of here. In our January meeting, there will be another report that is released in regards to another use of force, which we'll talk about that one in January. But there were some very troubling comments made, at least from our perspective, in regards to that use of force and the review board. And a lot of it comes down to necessity, government interest. Why do we have to use force in this scenario. And this time around, it got a little bit more, well, let's just say there was a robust discussion in the review board, and different versions of what occurred on that review board came back, which created a strong interest in myself to find out exactly what occurred. And I will tell you that I have had conversations with Director McConnell, Chief Hall, Assistant Chief McNabb. Today I spent 3 hours at the Police Academy with Lieutenant Jensen and Lieutenant Reese in regards to what occurred that day and what we expect going forward. And I'm adamant that we focus our review boards on trying to reduce the necessity of using force moving forward. And any sort of idea that we are to justify or try to come up with reasons why force was used, as whether it's proper or not, those decisions are already made prior to the use of force review board by the chain of command. Our job is to determine whether or not we want to see this thing again in the future. I've made enough noise about that inside of the police department that I could just tell you that from right now, for the 10 days or so that we've been talking about this, I am really impressed with the attention that the police department is actually taking to these concerns. So I'm hopeful that I will be able to come here in January. I'll give you a full brief on the report, what occurred. I'm not going to mention it right now because that'll take my January brief, but it is really nice to be able to say something and have a chief kind of agree. Now, whether or not we're going to go in a specific direction, I think that we will find some interesting and helpful adjustments made to our review board process. I think a large part of our discussion today was how do we get that feedback back to officers so that they get those extra tools. So that's something that's occurring right now. It's taken just an amazing amount of time from our days, but it's focused and it's timely, and it seems to be in line with these last reports have done. So that's what we're working on right now.
Thank you for that. Any comments from commissioners? Okay, thank you. There does seem to be quite a bit of use of force theme over the past 4 years I've been here. So, okay, so moving on, we're going to go to commission business. Just want to let y'all know, time check is 6:55. So, we are running a little behind, but again, we have a packed schedule. Before we go into more of our second topic in commission business, I do want to highlight that we have somebody new sitting to the right of Commissioner Rose, and we went ahead and went with the Riverside Law Group as our legal counsel, and we have Brennan, who goes by Boone. Well, it's just written in front of me.
Take credit for it, man. Take credit for it.
Here, so Brennan, just giving you a floor for a minute. If there's anything that you want to say, your first meeting with us as our legal counsel.
I'm just really excited to be here. Looking forward to assisting the commission in doing its work effectively and in compliance with all the applicable ordinances and legal provisions of the state of Washington. And it is fun to be able to, I'm on another city commission, but I always have to say this is not legal advice. But I'll finally be able to say this is legal advice.
Yeah, there we go.
Yeah.
Appreciate it, and it's great having you, and thank you for joining on with us. And if no other commissioner has anything to say, we can move to the NACOL annual conference recap. Okay, who's giving us our recap? Is that you, Mr.?
I did attend, and I will do in honor of how much time where we're at with time, I'll keep my comments brief. I always appreciate being able to go to a NACOL training, which was in Tucson this year. And everything that we talk about on this commission is addressed at this conference, and you get to find out what departments or what cities are doing things well, and and how commissions are doing as well. And I will just briefly talk about a new wrinkle to the NACOL conference, and that was the first time they offered a board and commission training. And I know I've been on this commission for a while, and I really found this to be helpful. So I'm putting a plug out. Even if you've been on this commission for several years, this is advertised as a training for new commissioners. I really found it beneficial to take what has been going on with this commission and then being able to hear how we're functioning or not functioning, and how we have come to be either effective or not effective. And I think from what I learned in that all-day session was that we are in an effective commission, that we have the dynamics that keep us moving forward, and that we're not in the category of dysfunctional. Although I think 10 years ago we had maybe a dysfunctional commission, but we won't go there. So they've talked about low functioning groups and higher functioning groups, and 10 principles of oversight, and then Tuckman's stages of group development, how the group is starting or forming, then you become this category of storming, and then you are norming or normalizing, and then you're performing. And that takes time, and this commission has done that. So I'll stop there. Just again, for those of you who go to Minneapolis next year, I would really highly recommend taking the time to attend this training. So, and I'll stop there.
Thank you, Commissioner Smith. Any? No? Okay. Well, thank you for that recap. And we're actually going to move to...
Chair Jasmine.
Oh, go ahead. I'm sorry.
Lieutenant Wheeler meant to be here today, but he's under the weather. But he'd like to address his feedback from NACOL at the next meeting. But he really wanted to, because we were able to fund that for him to have. It's the first time we thought to actually take the internal affairs lieutenant. Probably should have thought about this a long time ago, to give them that perspective. But he was grateful and appreciative, and he wanted me to pass that to the commission.
Appreciate that. Okay. We're going to another very important business here, and it's the chair and vice chair elections. If I may, it's been fantastic serving as chair for, I don't know how is it 2 years? It's been two. Yeah, 2 or 3. I don't know. It's been the best of times and the worst of times. But what I would like to do this upcoming year is maybe take a step back. And if it's okay with you all, Commissioner Rose, I would love to nominate you for chair for 2025, if that's something that you're...
Yes, I would be interested in that.
Okay.
Thank you for thinking of me.
Yeah, I don't know if there's anyone else.
I would also concur. I know we have 2 new commissioners, and I think it would be wise to wait for a year before. But that's just my opinion. But no, I would like to nominate Jenny Rose to be the chair for the upcoming calendar year, and And I will refrain from being in any kind of office or a position due to the fact that I'm probably, I am going to be termed out here pretty soon. So I will leave the important work to those who are going to remain on the commission.
Mr. Welzel and Commissioner McCollum, do you have any thoughts, comments?
Certainly vote for Commissioner Rose.
Then I would also put a nomination out for vice president. That would be awesome if Mr. Jasmine, Commissioner Jasmine, would you be willing to take the vice chair?
Thank you so much. No, it is important. I think if you're willing to be chair, then being vice chair,
It's easy.
yeah, I'm willing to do that. And hopefully the year following that, our two new commissioners are able to, yeah, that'd be great. Okay.
I'll put a motion out. Legal advice, do I do this separately or in one fell swoop?
I would, you could do them together if they're moved and seconded.
Okay. I move that we nominate Commissioner Jenny Rose as chair for 2025 and Commissioner Luke Jasmine as vice chair for 2025.
Second.
Okay, we have a motion and a second. All those in favor, aye?
Aye.
Thumbs up, okay. That unanimously passes. We're gonna go to, well, congratulations.
Well, thank you very much.
Yeah.
It'll be the end of my 9th year. I feel like, where did the years go? So I appreciate that. Thank you.
Yeah. Commissioner Speak Out, that's where we're at right now. Do any commissioners have anything you want to?
I have something very, very brief. I attended a meeting with Ms. Debbie Novak in November at the Shadle Park Library, and it was 2.5 hours. It was a long meeting, but it went fast, with the Office of Independent Investigations, which was, I mean, it was a whole new learning experience for me. They talked about the office. They talked about their first actually brick and mortar would be in Tacoma. And we were like, what about Spokane? I just appreciate being invited. And they also asked if they could come speak at our meeting next month. And I'm going to ask Ms. Cody if they will be here, or do we have any more information on that?
Not at this time, but
Okay.
I will get back with you shortly.
It is just to listen to them. I'm like, okay, what entity is this and where do they fit in? And I think the group there that night, it was just amazing to listen to the different stories of people that have experienced excessive use of force. And I just appreciate everybody being so open and willing. It was great.
Nice, thank you for that. Any other commissioners?
No, thanks.
Okay. Amy, you have anything?
I just want to say thank you to the commission just for allowing me to go to NACOL and to this use of force conference. I just learned so much at NACOL, and I was able to go on a ride along the day before the conference in Tucson, which I felt like really gave me a really great perspective on policing. So I appreciate that you all made it possible for me to go down a day early and do that, because I feel like it gives me more education on what I'm overseeing. And so thank you.
All right, appreciate that. And, you know, what I'll say is another year of learning, another year of, I'm glad that we have a full commission this year. That's huge. We've been talking about that for several years. And, you know, I was hoping we could, I don't know if there's any contract conversations happening that we might, you know, want to talk about, or if you're still able to hire your own deputy. So those are some things that are on my mind. I know we're crunched for time, so we could talk about that at the next meeting if we need to.
I can give you a small update on that. The hiring of the deputy is very, very important. There are some other things in the contract that I'd like to see adjusted. Some are less pertinent than others. But overall, I've talked with the police guild, and I've told them that I would like to go through and do a full deep dive, red line, so that they know exactly what I think, all from the get-go, all up front, no surprises. I generally try to be pretty transparent in regards to my thoughts and some of the restrictions there. I think that reporting, in my opinion, is something we could look at moving forward. But they're still under contract for another, I think it's 2 more years for this one. But I did specifically bring up the deputy hiring thing, and I actually spoke with President Duncan, I think after last meeting, and we came up with, well, let's meet. So we did have that meeting. Actually, it was the same meeting where they came in 5 deep, so they had the numbers. But I offered them an idea, and President Duncan has brought that idea back with me today, which we will take up to the administration and see if we can get an MOU done on that. That's as specific as I want to get at this point in time.
Appreciate it. The last thing that I'll say before we head into executive session is I like the fact that we have so many of you in the crowd. I see some of you taking notes, so that's fantastic. When we were going through the reports, I saw y'all feverishly going through and checking it out, and that just makes me happy. And thank you for being here. And if there's anything that you want us to add to these meetings, I'm sure probably being shorter, but any people that you want us to have here as guests to speak and do Q&A with, we're always open and looking for those suggestions. So just wanted to just send a special thank you for being here today. And then I'm going to read this here.
We do have one more
we do.
December meeting.
Oh, yeah. Okay, so right now, currently, we have our next meeting scheduled for December 17th. Since we've kind of met our goals for the year already, I would like if we canceled that meeting and just continued with our regularly scheduled meeting in January.
I'll make a motion that we do not meet on December 17th, since that's only 2 weeks away, and that we reconvene on January 21st, our regular meeting time.
I second.
Okay, motion and second. All those in favor, aye.
Aye.
All right, we got thumbs up. Okay, so that passes. Thank you for that. Okay, so now moving to executive session. We are going into executive session to review the performance of a public employee under RCW 4230.11.0, and we'll reconvene at, how much time do we want to give ourselves? It's 7:11 right now.
7:16. 7:20.
At 7:20 p.m. unless the executive session is extended at that time by further announcement. Okay?
Okay. Take this in. Yes.
So I'm going to call her and give you guys the phone. Hi, I am giving the phone to the rest of the commissioners so you can go into executive session with them. Okay, and you'll be on speaker in there, but make sure you're muted on your computer, which it looks like you're good. Okay, here.
All right, fine. How are you?
All right.
we'll be extending the executive session until 7:27 PM. we will be extending the executive session until 3:34 p.m. 7:34 p.m. Correction, 7:34 p.m. It's been a long day. All right, we're just waiting for the rest of the commissioners. Okay, so we have concluded executive session at 7:34, not 3:34. And we have approved the OPO evaluation. We have also approved a agreement between the OPO and the OPOC about secondary employment of Bart Logue and Louis May Omana. Sorry about that.
Oh, you said it right.
And is there anything else I need to do there? Yeah, and actually, can we do a vote on the secondary employment of Bart Logue and Louis May Omana? Oh, so for both, okay.
Yeah, we need to do a motion.
Okay, do you want to?
I will make a motion to approve the commitment for the secondary employment of Bart Logue and Louis May Omana.
Second.
Okay, so there's a motion and a second. All those in favor, aye?
Aye.
Aye.
All right, thank you, Amy. Okay, that unanimously passes. And with that, our meeting is adjourned.
Thank you.